this basic idea of governance as steering the boat. If you remember, those of you who were there at the first one, remember that. And last week we looked at getting the balance right between board and manager and allocating roles and responsibilities. And one of the big messages there, not the only thing to remember, but one of the big messages there was that the most important thing is being clear and agreed. It almost doesn't matter what you agree on, as long as you're clear and agreed who's doing what, because then the things will be done and you won't be treading on each other's toes all the time. So at one stage we talked about it's important to have a governance model, and the governance model is just a system by which people have a general understanding of who does what, when, and how. But it almost doesn't matter what model you pick, and the research supports this as long as everyone in the group is clear and agreed about that. As with all things about community, that's true, but. So today we're going to do one of the buts. There are some legal responsibilities. So these are the non-negotiables. That no matter what model you pick up or how you operate, there are some legal responsibilities when you take on the role of board member or trustee or committee member. And essentially, they are summed up in the idea that the buck stops here. So you are responsible for everything. Only in your organisation, everything that it does. And even if, no matter whether you delegate it or not, you're still responsible for what happens. So it's okay to delegate decisions to other people, and it's okay even not to check up on them if you've got absolute 100% trust that they will do things right, because you are the one who is responsible if there's a breach of employment law, if there's a breach of Income Tax Act, if there's a breach of the Occupational Health and Safety Act, no matter what nice things you've said about delegating them to someone else. The responsibility, the decision making can be delegated, but the responsibility stays with the board members. Excuse me. So, before I go any further, I'll just explain that I'm really feeling sick. So, if I collapse on the floor, it's not an act. It's not a part of the thing. So I did actually. I thought if I'm really feeling sick, I brought my own bucket to keep. So then you know it's come and help. But I think I had food poisoning a couple of days ago. I'm still kind of recovering from it, and I was travelling as well, so all that kind of makes me feel a little bit weak and a little bit lower energy than usual. So it will mean I'll probably sit down a bit more, and it may even mean that I casually walk out to the toilet, if I need to, but hopefully I won't. I think I'm over most of that now, but I did bring some lemonade and caramelised ginger there to keep me going, which I've got a bit of surviving on. So we're going to start just by looking at what is the law first, and then we're going to look before we look at the specific legal requirements on us as board members. So, we're going to start with what I like to call Garth's 30-minute law degree. Now, I have to tell you, this 30-minute law degree is recognised by no institution anywhere in the world. So it's a universal degree. It's equally unacceptable anywhere. So you can take it wherever you go with the same authority. But hopefully it will give you a bit of a quick introduction into what laws are and how the legal system generally works. What I'm going to do is to first of all, as everyone enrolled in my 30-minute law degree, to do most of the work. So, first of all, what is a law? What do you think a law is? Any suggestions? Definition of what a law is?
What another word? Rule?
It is like a rule. It's a particular type of rule, though, isn't it?
rule made by the governing body of the country.
Yep, and there's something that goes with being made by a governing body. What does a governing body of the country have? That other people, yeah, authority and an army and a police force. So basically, the thing that makes a law different from other rules is it's an enforceable set of rules. So there's some force behind it. So it's that army or police force or the threat of them. Where will I do my law degree? Over here, I think. So a law is an enforceable set of rules. That's the only difference. It can be enforced, so we need to do them, or we might suffer, or we will suffer the consequences. Even if you believe in civil disobedience, you still get to suffer the consequences. Okay. We live under one type of legal system, which is called the Westminster system, because it was derived from the UK, their system of government. And under the Westminster system, there are two, and I'm going to add a third, or concentrate on the main two types of laws. Now, I'm not talking about types of courts. If you're any good at watching TV law dramas, you'll know the difference between civil law and criminal law. So criminal law is when the state enforces it, and civil law is when a person takes a case against another person. So I'm not talking about that distinction. What I'm talking about is these are different types of laws. They come from different places.
Statute and case law?
Sorry?
Is it the case law and statutes?
Yes. Have you done my course before?
No.
Oh, right. Very well done. People usually take a long time to get that one. I have 3 more clues before.
Oh, we're going to be finished in half an hour.
Yeah. Sorry, I'll just put the question up first. Yes, so basically in Westminster systems, there are 2 main types of law. Statutes, which is just another name for legislation. Anyone know the difference between a statute, legislation, act, and bill? Anyone know the difference between those?
Part of the hierarchy, presumably.
No, not exactly. They're all the same, excepting a bill is just a draft.
Wow.
So act, legislation, and statute are all the same things, and until it becomes passed by Parliament, in fact, technically until the Queen or the Queen of New Zealand, or her representative agrees to it and puts her stamp on it, then it's an act, a statute, or a piece of legislation. Up until that point, it's just a bill, so it's a proposed act, legislation, or statute. But those other 3 words mean the same thing. So we heard there are 2 types: statutes or legislation and case law. I think you call it. Is that the term you used? Yep. Right. So the first question I'm going to ask other people, because you obviously know too much, is where do these come from? Who makes these? So who makes the statutes or legislation?
Parliament.
Parliament, yes. Yeah. So we have a whole institution whose pretty much sole purpose is just to make laws, statutes, legislation. Who makes case law?
Judges, essentially.
Yes, yeah, the judiciary or judges. Yeah. And in fact, one of the principles of the Westminster system to try and have a kind of balance, so all the bits balance each other, is this very high principle called separation of powers, so that the judiciary always have to be separate from the government. So even though they may be appointed, they're appointed for life, so government can't knock them off if they don't like them. There are very strict rules. You've got to be insane or something else before you lose your job as a judge. So it seems like a good job to have. There's this kind of expectation that they will operate separately and not try and interfere with each other. So judges won't criticise government, and government won't criticise judges. So when a member of the government does stray into criticising judges, you'll find an uproar, especially by constitutional lawyers who will be horrified. It's basically like killing your mother for something to happen. And the rest of us might not have noticed, but they will be shocked to their socks because it's a basic principle that these things are kept separate. Now, why on earth would you have these two systems? If we've got a perfectly good, perfectly serviceable anyway, Parliament that can make laws, whatever laws we want, why would you have a judiciary also making laws on the basis of cases or precedents?
Because life doesn't stand still. Things move on.
Yeah.
And so otherwise the law gets out of date.
Out of date, yes, yep.
Is that interpretation?
Yes, yeah. So there's, and basically I think between you've covered the two main reasons. So that case law has a role in interpreting the statute. So if there's any disagreement about what was meant, judges have a role to interpret. And if there are any gaps, because all of a sudden someone invented the internet, and does copyright, which only used to apply to books and movies, apply to the internet or other things, or so people have to make up laws to fill the gaps until Parliament does so. So either for interpretation or to fill in gaps that may be because of changes or may just be because of new emerging issues or something that no one had thought of before. So I'll just say, excuse me, not dying, just coughing. I'll say just a little bit about this case law thing, because it's a funny system. We probably have a bit of a gut feeling for how it operates, but what it means is that judges can make a decision on an individual case, so individual a point of law, of dispute that's taken before the courts, but they can only make that decision if it's consistent with all the other decisions that judges have made before them. So that's why this is sometimes called precedent, because it's about the precedence of what's happened before. But the judges then say, oh yeah, this situation is like that case, I remember, and therefore the outcome of this will be you're right and you're wrong. So it's like remembering old cases and saying it's like that, therefore this will be the decision. So that's why in court, including on TV dramas, occasionally, though less time seems a bit more into dramatics these days, but occasionally you'll find lawyers trying to find the right precedent that supports their point of view. So they'll try and find a case that is similar enough and supports the outcome that they want, and the opposition will try and find another case that supports what they want, and both of them will try and convince the judge that the case that they found is the most relevant, closest fit to the circumstances. So the judge is using judgment, human discretion, to try and work out which previous decision this most closely resembles and what is the implication for future decisions. So although it looks like a backward-looking system, it's always creeping forward and expanding or changing the direction of things, like applying copyright to the internet. Because it says, okay, well this is all the decisions about copyright and books, and really the internet is just like a a very big library with lots of books and lots of pages in it. So therefore, we will apply the law of copyright to the internet in this way. Does that make sense? So looks backward looking, it is often changing things, and especially trying to adapt things to fit changing circumstances. Okay, so I said there were 2, but really 3 types of laws. This will be a really hard one to guess what the 3rd type of law is, though in this part of the country you have had direct experience with it a while ago, a decade or so ago, because it doesn't often come up. Any guesses what this other type of law is? So we've got...
Presumably you're talking about the water thing that started in the Marlborough Sound.
Yes, yeah. Seabed and foreshore, if you're on the right track. Is that...
Yeah, that's what I was thinking.
Yeah, where does that come from? What law? What law is that? Sorry?
The treaty.
Yeah, so it actually doesn't it doesn't rely on the treaty. And that case didn't solely rely on the treaty, though the treaty was used parts of the case were taken to the Waitangi Tribunal. But there is an even broader thing that applies across all Westminster jurisdictions, including Australia, which doesn't have a treaty, and that's this principle of customary law. Now, it doesn't come up often because it's a very narrow set of circumstances. For customary law to apply, there has to be no case law that already contradicts it. There has to be no parliamentary legislation that already contradicts it. And it needs to have been the right that's under examination or being asserted needs to have been operated continuously since before European settlement. So this is a law of the colonised. So if you have been doing something before European settlement and you've been doing it continuously since, so it hasn't stopped, and there's no case law that contradicts it, and there's no parliamentary legislation that contradicts it, then the customary laws can apply. So that's why, even in the end, people were not sure whether there would or would not be a customary right about the foreshore and seabed, yes. And it hadn't been, and the iwi here were about to take it to test the case in court and to let the judges test whether there were no cases or legislation that had come across it. And they would also test that there had been a continuous practice of harvesting kaimoana by Indigenous people since in that area. So in that particular case, since before European settlement. So it's a very narrow thing, but it was probably the thing that almost divided the nation. It probably led to the ultimate defeat of a government. It led to the emergence of a new political party. It led to a whole lot of things. And that was even before the case was actually taken. Because what happened was, the government of the day stepped in and said, before you even have a chance to check this out, we're going to pass some legislation to say there is no right. And the way this system works is this trumps this, and this trumps this. So if there's a statute, it rules. If it's in conflict with any of these. If there's no statute, only case law, it rules. So both of these have to be absent for customary law to rule. So the government of the day came in and quickly passed a piece of legislation, which I've now forgotten what the legislation actually said, because it was then reversed by the incoming government to say that no one owned the seabed and foreshore, and we've been left in a bit of a hiatus about what to do with water generally ever since. So one day we'll be brave enough to tackle that issue. But that's the impact of customary law. It is very small and specific, but it can have wide-ranging repercussions. And in fact, so as an Australian, I'm particularly aware of its significance because it is the whole basis of Aboriginal and Torres Strait Islander land rights in Australia. There is no treaty, there was no legislation initially ceding land rights or any rights of occupation to Aboriginal and Torres Strait Islanders until a guy called Marlborough took his case to every court in the country and incidentally lost at every level until he got to the High Court of Australia. So it was only at the final High Court that he won the case. And the main reason that he was able to win the case of being able to show continuous and exclusive occupation of his family and ancestors of this particular island off Queensland was that that island had been essentially run as a concentration camp because the Native Affairs policy was to segregate Aboriginal and Torres Strait Islanders into particular areas, and in coastal Queensland that meant these coastal islands, and you had to have a pass whether you were a European wanting to go out of the island or an Aboriginal wanting to go off the island to move. So it was I think the kindest way of describing it is a reservation, but it was basically a way of concentrating the population, so I think that's what a concentration camp is. And it was only because of that Queensland happened to have the most repressive policy that enabled all the necessary points to be established in the High Court for the customary law to apply and for there to be a basis for Aboriginal and Torres Strait Islander land rights. And then all the states quickly legislated so to define what those land rights were so that it didn't get out of hand. So that led to the recognition in the state legislation. Okay, so I think that's the main things I wanted to say about that. So that's basically how the legal system works. Most of you who've been here before know that there is a fabulous prize for the most colourful and messiest placemat that you managed to decorate by the end of tonight. So that's what the pins are. I understand some people brought along their own art supplies to get a head start. It's very competitive, this.
They're trying to take the crown away from me, Joe.
Yeah.
I thought about it. I thought maybe I'll take my pencils.
And we've got an absolutely fabulous prize tonight. It's very legal. That's all I'm going to tell you. So you'll, I think you'll see on there, yes, a chart called Table of Authorities. So in these laws that we've just talked about, as I've already hinted at, there is a hierarchy. Some laws are more important than others. And so this is called a table of authorities. So the one at the top has authority over the ones underneath. So if there's any clash or conflict, you have to obey the one at the top. So I'm going to give you a series of types of laws, and see if you can put them in the correct order with the highest authority on top and the lowest authority on the bottom. Okay, does that task make sense? So don't start yet. You give people a head start, just because they're sitting up the front. But you can get close so that you're in arm's reach of them. You want to?
Yeah.
So you can open the pile. Yeah.
If a lawyer is trying to defend a client and looking at cases, can we refer to constitutional countries overseas or just in India?
If there's nothing in New Zealand, there is a precedent of judges looking to other like-minded jurisdictions. So the motherland is always the first place of call, but also Canada, South Africa, other Commonwealth countries, Australia, you can refer that, but you have to exhaust New Zealand first.
So legislation.
So at the top will be the one who has authority over everything else. Overrule the rest.
You can't say something that your organisation will do that's considered illegal.
How it's customary done.
And then any regulations.
Regulation.
It might be done there, but time doesn't say it's been done. It used to be policy.
It's a regulation for other Yes, that's just meaning. So there would be a change to constitutional aid. That's just what you do because of the reserve.
So this is every business.
Which isn't a good reason to do anything.
Okay, so let me know when you've locked in your answers. So this term is locked in their answers. Have you locked in your answers? And you've locked yours in?
Constitution.
And you're right with your answers? Right, okay. So we might start with green. So I think they were among the first to finish. What did you put at the top of the heap that overrules all others?
In New Zealand legislation.
Right, let's have a look and check if you are correct or not. Yes, you are. Well, I thought it was good. It's a hard audience though. Okay.
We're all going nicely, so different.
Everyone get that? Yeah. Okay, what did you have for the next one?
Judgments by any New Zealand court.
What do people think?
Yep.
Yes. This is easy, isn't it? Okay, judgments by a New Zealand court. What did you have for the third one?
Organisations constitutional trustees.
Organisations constitutional trustees. No. Organisations regulations and bylaws.
No, the ones that are adopted by the organisation. So the bylaws are from someone else.
No, there's the organisations bylaws.
It's all trustees. The Constitution.
Right, you're changing that. So, sorry, I must have worded it ambiguously. So the regulation and bylaws are the organisation's regulations and bylaws. That's not clear. So you thought it was the Constitution.
Yes.
What did other people think?
Constitution.
So the Constitution seems to be winning the vote. And you are correct again. Organisation's constitutional trustee. What comes next?
Then the organisations duly adopted bylaws or regulations.
Right. People agree with that?
Yes.
Yes, well done. It's getting easier and easier as you go down, isn't it? There's not a lot left. What do you have as the next one?
What's that? Written policies. So
Yeah, we-
written policies.
Written policies, and then how you usually do things around here?
Yes.
It doesn't necessarily mean that they are any of the above.
Yes, that's correct. Wonderful. Very well done. So you've all passed my degree. It's absolutely useless, but you've succeeded spectacularly. So this also means there's no point anything that we do in here down being inconsistent with those things, because they will overrule it at any time. So we can't make our own rules. And when we set rules within our organisation, they have to all be consistent with our founding document, trustee, constitution, or whatever we call it. You know the difference between a bylaw and a regulation and a policy?
Bylaw is like a local council.
No, we're talking about organisations' bylaws. Yeah, anyone can have a bylaw. Can be councils have them too. But the organisation's bylaws in this case.
Bylaws a rule and a policy is how we're going to do it.
What do other people think?
Well, I think
No
the
idea.
council's a good example to look at, really, isn't it? It's
Yeah.
like, it's like an act, almost act,
Yeah.
The bylaws are localised within the organisation.
Okay, I can see you're struggling, and that's for a very good reason. It's whatever we say they are. So, generally considered, regulations are considered to be more entrenched, less easily and regularly changed than policies. But it's just a matter of degree where you stop and start that. And whatever you call a bylaw or regulation is a bylaw or regulation, and whatever you call a policy is a policy. So there's no independent definition of these things. They are just whatever you choose to call them. And some people will have some but not others, or vice versa. I want to tell you a quick story about how things are usually done around here. This is a $1.8 million story. It was a time when I was a volunteer at the law centre in Christchurch, and most of the time you do the same kind of boring work of helping people get their constitution in order, sort out their tax status and all that kind of stuff. Because I did the voluntary sector work on my shift. But one day I had this interesting inquiry. Oh, you also got conflict. Groups in conflict would come along and think there'd be a legal solution to them hating each other. There usually isn't. But anyway, they were always interesting now. It was also interesting having to tell the mongrel mob that I don't think it would be really ethical to help them get a non-profit license for a bar. And they said, oh, okay, and walked out. It was a great surprise for me. But the other interesting thing was, it's amazing these people that respect legal systems. Anyway, this day, a big delegation, usually it's only one or two people, but a big delegation, there's about 6 or 8 women came from this organisation. And they obviously all wanted to hear what was said rather than trusting each other. They said, tell us, is it legal to have proxy votes or not? So that was the innocent sounding question at the beginning. So, of course, the legal answer to every dilemma is, it depends. So I was able to give that with great authority. And I said, so tell me a little bit about the situation and why you need to know this and what's the context and whatever. So, it was an organisation that had not really been functional for a few years. Not a long time, but a few years. It was a long-standing organisation. So it had acquired considerable assets, including its If it was a youth group, it might have been called a clubhouse, but it was where they met and had activities. And it was on a piece of land in central CBD Christchurch, and an historic building, and it was worth at least $1.8 million. Because the organisation hadn't been doing much for a while, some of the former members thought we should just wind this up and distribute the assets amongst the members. You know, who's going to sneeze at 1.8 million? But of course they had to go through a process to do that, and they did that correctly. They notified all the people who had been members that they had on rolls in recent times, and called a meeting. And as it turned out, when people came together, about half the group did want to wind it up and share out the assets amongst themselves, but the other half got really enthusiastic about the mission of the organisation again and wanted to reinvent it for a new era and get involved and reinvigorate the organisation and get it going again. So there's this fundamental disagreement, you know, to die or to reinvent. And though we're going through the processes because it's been initiated by the Die faction, so they're going through the process of winding up, and they knew they had to have a vote at the next meeting. There needed to be 2 meetings that agreed to this, that need to be a majority in favour of winding up. And the long and the short of it was, one side knew that if they could have proxies, they would win, and if you couldn't have proxies, the other side would win. So whether we had proxies or not in this organisation was a $1.8 million question. And all in the end rested on how do they usually do things around here. Because we went meticulously through all this other process. So I knew there was no legislation to provide guidance. That was easy. I had some students do a search to see if there's any case law in New Zealand or Commonwealth countries about whether there's a default view about proxies being or not being allowed and in non-profits. And there was nothing. There's a little bit in company law, but that was questionable about how it would be applied. The organisation, of course, had nothing in its trust deed or constitution about proxy voting. It had no bylaws or regulations. It had no written policies. So it all swung when I asked the group, well, tell me, do you usually have proxies? And that decided the fate of the $1.8 million asset. Now, to some extent it may be unfortunate, but the people that keep the organisation going won. And then the Christchurch earthquakes happened, and the asset lost a lot of its value. Not all of its value, but it certainly set them back a while. But that all just hinged on just how things are usually done around here, because everything else has been neutral. Okay.
So that's protocol, is it? Yeah, right, okay.
Yeah.
Cool.
Yeah. Okay, so let's have a look at the founding document, the legal identity that gives you the legal identity to your organisation. Now, the first thing to say is that in the Westminster system, you don't need to be registered with anyone to be legal. So you can have you can be operating, have no written constitution or your own little written constitution on the scrap of the back of an envelope, have never got approval from Inland Revenue or Companies Office or anyone, and it's perfectly legal to operate. In other jurisdictions, that's not the case. So under Napoleonic law in the Francophone countries, you actually have to be approved to be legal, or otherwise you're an illegal organisation. In Westminster systems, the government has to declare you illegal, and it sometimes does that to terrorist organisations and other groups. But you can be have no legal identity and be perfectly legal. But many organisations decide to have a legal identity, and that's called incorporation. So for those of you who brought along your constitution or trust deed or founding document, you might want to pull it out and have a look and see if it gives you a clue, and share it with other people at your table if you're happy to do so. If it gives you a clue whether you're incorporated under some act or not and what it might be. Or you might know, just know. So if you're anything like me, you'll probably need your glasses on for this, but just have a look at the green labels at the top. They're the main piece of legislation that would be incorporated under. So if you want to know your statistical chances are, 50% of you, if you were a typical room full of non-profit organisations, 50% of you would have no legal entity whatsoever. You would not be registered with anyone, no one would know you existed unless they fill up upon you. So that would be like arts and crafts groups, clubs, church women's fellowships, a lot of different youth groups that are many sports clubs at a local level. 50% have no legal entity at all. Of the other 50%, about 2/3, so what's 2/3 of 50? I don't know. About 2/3 are incorporated societies. And even though it's got the word incorporated in it, it's not the only way of being incorporated. That's just to confuse you, because lawyers like to do that. So all of these are different ways of being incorporated. The incorporated society is just one way. The next most popular way, which takes up almost all of the rest, about 95% of the rest, is a charitable trust. So you can be incorporated as a charitable trust. And then there's a whole lot of little ones that make up all the others. At the most, they would be maybe 2 or 3% of the total proportion of non-profits. So that says cooperatives, political parties, charitable or non-profit companies, Te Tura Whenua or Māori land trusts, or if you're really big and old, they're not necessarily ugly, you may even have your own legislation. So the example of that is the Church of England in New Zealand. Yes. So the big and the old do get their own legislation, which makes them feel important. But I tell you what, it's a heck of a job when you want to change your constitution. You have to get Parliament to agree, because it's its own law. I don't know about fish and game. It could be. It could be. Yeah. The Society for the Blind has its own legislation. So we wanted to be the Society of the Blind. It had to go through a very expensive and long and painful process instead of being for the blind to be of the blind, because that required change of its own law and its own act. But they're the kind of rare exceptions, but fascinating. Okay. So, have people worked out what they might be? Most people know. Yeah. Okay, so just hands up so I've got an idea of the spread in the room, so I know who I'm talking to. Incorporated society. Yeah.
Volunteer Marlborough.
Yeah.
We're both.
And a charitable trust. Yep. So you're about representative of the national percentage breakup, about 2/3 and 1/3.
Is it normal to be both? We're Volunteer Marlborough is both. We're registered charitable trust and an incorporated society.
No, charitable trust, charitable.
You're not incorporated as a charitable trust board. It is unusual to be both. I've not seen it before.
I've got both certificates on the wall in the office. Yeah.
Right. Maybe it's like dual citizenship. If you don't tell the other country, they don't know.
To clear that up, because we were incorporated societies, and when the Charitable Trust Act come in.
No, Charitable Trust Act has got nothing to do with your legal status. It just means whether you can call yourself a registered charity, and you get certain tax concessions. So the Charities Act doesn't give you any legal status. It just allows you to use the name registered charity and allows you access to certain tax concessions as a result of that. So you can be a charitable trust who is registered as a charity, or you could be an incorporated society who is registered as a charity, or you could be a company who is registered as a charity, or a cooperative that's registered as a charity.
Okay, so you need to clarify this middle one, charitable society. What do you mean in there?
Because our registered trading name is Volunteer Marlborough Charitable Trust.
How is that different from incorporated society? That's a charity.
Yep, I'll explain that in a minute.
So answering Meg's question, that's what we want. Can she be both? Yeah.
Can you be both? Well,
It would appear so.
You're a charity, but
well, if you are, you are, but I wouldn't have thought you could be.
No, it was like that when I started.
Right, yeah. Well, in this gender fluid age, I think, why can't we be legal identity fluid as well?
There's some legal complications, of course, if that would be true.
It would mean you'd need to satisfy 2 sets of requirements, 2 sets of returns.
Because members can have a say that
Yeah.
totally
We have
different.
members, and members vote on things, and we don't have the legal members.
So, the origin of the 2 main types, so I'm just going to talk about charitable trusts and incorporated societies. Incorporated societies the law was designed, and New Zealand was one of the first countries in the world to have this law in 1901, and it hasn't been changed much since. It's been amended a little bit, but there's still a basic law, and other countries have copied it. But it was the purpose of an incorporated society was to enable membership groups. So where members wanted to do things together, to achieve something together, and they wanted the organisation to be accountable back to the members. So it's a membership association is the kind of rationale behind it. A charitable trust use the legal concept of a trust. Instead of holding it in trust for a named beneficiary, you held assets in trust for a charitable purpose. So whatever people might come along that might need. So the idea so this is like providing a service or help to others. So instead of a membership group, the charitable trust was designed to provide in perpetuity a mechanism for helping others, whatever the other might be. And there's a 500-year-old law in England from Elizabeth, the first one, that describes the 4 gateways into being a charity. I think the 4 heads of charity: education, religion, the 4th one, what's the 3rd one? I've lost it.
Poverty.
Alleviation of poverty, of course, yeah. Education, religion, alleviation of poverty, and any other any other purposes of a general public beneficial nature, as agreed by the government at the time. When it was originally set up, bridge building was one of those things that came under the other category. So if you built bridges, that was considered a charitable activity. And I mean literally bridges, not social cohesion, getting over a creek. The walls were never a charitable activity, I should say, building them or otherwise. Okay, so they were the two purposes. But very soon lawyers got to play with this and muddled up things. So they developed trust deeds which added in members. Because under the pure charitable trust, they are called self-perpetuating governance. And the existing trustees appoint their replacements, so they're self-perpetuating. But some people wanted to have a little bit of the best of both worlds. And they invented membership, so in trusts, and those members got to elect the trustees rather than just being appointed by the existing trustees. So a wider group of members elect the trustees. Even still, because of the way the laws are framed, there is a fundamental difference in that in an incorporated society, members can always overrule whatever the committee or the board does. They can always call them to account at a special meeting. They can undo any decision they make because the members are the ultimate authority. Even in a membership trust, which is sometimes called a democratic trust, if you come across that term, but I think it's easy to call it a membership trust. Even in a membership trust, although the members can elect trustees, once they elect them as trustees, they can't interfere because the trustee has the legal responsibility for the final decisions. And so all you can do is sack them when you next get a chance to sack them. If there's something in the trustee that says you can sack them, you can't overrule their decisions or call a meeting and contradict them or whatever. So there's still that tiny little difference. So they're sometimes also called charitable societies because they're a mixture of the idea of a membership society and a charitable trust. But basically they fit under the Charitable Trusts Act, so they need to legally, at this higher level, meet the requirements of the Charitable Trusts Act.
But this is what's happened, is that we're generating these charitable societies because government requires it, because they want someone accountable.
Yes, yeah. And Matt and I were at a meeting a couple of weeks ago where people were saying, actually, do we need all these governing boards? We need all these people involved in communities, but why do we need all these governing boards, and are there better ways of governing and supporting community activities, or we just keep trying to push square pegs into round holes? But anyway, it'll be a long time before that changes. So we've got to work with the existing system at the moment. So there's this range of different options. And they each designed for slightly different purposes, and they each have different advantages and disadvantages. So in a incorporated society, you need to have 15 members. There's a proposal to change that, but at the moment it's 15 members. But if you have an organisation that's already incorporated as a member, it counts as 3. Okay? So if that organisation is unincorporated, it only counts as 1. But if it's incorporated, it counts as 3, no matter what law it's incorporated under. So, but you've got to have 15 in total. So, try this quick quiz. If you had 1 unincorporated organisation member and 2 incorporated organisation members, how many other members as a minimum would you need to have, individual members? 4. 8? What do people think? 10?
Well, you only need 5.
So you got one unincorporated, so that counts as 1. You've got, I said 2, didn't I?
Yeah, we said
Yes.
incorporated.
2 incorporated. So that counts as 2 times 3 is 6, and that's 1 is 7. Minus 15 is 8. Yes. Your mental arithmetic is still spot on. Okay. So you get the idea. It sounds more complicated than it is to actually work out. Whereas if you're a charitable trust, you only need a minimum of 2 trustees. If you're a company, you need to have a minimum of 1 shareholder. That could be an organisation or an individual. So there are slightly different variations of the requirements that are because of the different purposes of these different bodies. But what I'd really like to talk about is the why you would bother behind it. Now, sometimes we have to bother because someone else tells us to, but I'm just going to put that on the shelf and say, okay, sometimes other people say we've got to get incorporated, I won't do this money or whatever. But apart from that, are there any other reasons why you would bother becoming legally incorporated, given that in Westminster systems you can still be legal without being legally incorporated? So just have a chat on your table first about this.
Accountability. It adds legitimacy to the organisation.
So I'll give you a clue which will hopefully confuse you even more. Okay, let's share your first thoughts about that. Why incorporate? Anyone? Liability, yes. You have done my law course before, haven't you? Yeah, all the right words. What does liability mean?
Well, there's a limited liability if you're incorporated.
Yes,
So you can't be personally held accountable with your own wealth.
Yeah. So when you incorporate, you limit your personal liability for what happens in the organisation's name. So when you're unincorporated, each of the leaders or decision makers is personally liable for anything that the organisation might do. So in simple terms, that means if you break a contract or do something wrong, your personal assets are at risk. You could be sued personally. So you might not think you own assets, but if you have a car or a TV or a dog, they are potentially at risk. You don't have to own a holiday home and a boat. Children, yeah. I think you can sell them off depending on who is suing you. No. No, not children. I should say that. I'm joking. Don't write that down. You can't sell your children to pay off a debt. I know. What are you for? You can send them to the mines to earn money to pay off your debt, but you can't actually. So, okay, so if without the protection of incorporation, you are personally liable. And because what happens with incorporation is it plays a legal game of let's pretend. it says, let's pretend this organisation is a person. So whatever the organisation does, it will have the rights and responsibilities of a flesh and blood actual person. Because in a court, only people have standing, real people. So tables can't take things to the court, inanimate objects. This has been kind of stretched to the limit, or maybe not the limit, but stretched beyond where it has often been seen as applying by, in New Zealand, as a part of a treaty agreement giving personhood to a river. The reason for giving personhood to a river was not just a nice feel-good thing, but it meant the river had standing in court, so that the river could protect itself, or people working on its behalf could operate in the interests of the river, and it could have standing itself. You didn't have to prove that you were another party with interest in a case.
Which river was it?
Wanganui, yes, yeah. I just lost the name, sorry. So it's part of Tainui settlement.
It's a very dirty person.
Yeah.
It's not as a cleanest river.
But a big long one. Sorry, now I lost the track. Yeah, that's what I thought.
Is there an element of seriousness too about incorporating that we are in this for the long haul? This organisation is going to live beyond us as individuals.
Yes. So part of the idea, part of what happens when you give something legal personality or pretend it's a person is that it can do certain things. It can sue and be sued. So the organisation can be sued if something goes wrong. It can own assets as an organisation, so it can acquire and accumulate assets. Previously, before you become incorporated, even though you think the organisation might own the photocopier, actually whoever went to the store and bought it probably is the owner of the photocopier. Though there'd be a terrible expensive court case to try and prove who it was. But the only thing we do know is the organisation couldn't own it because the organisation wasn't a person, so if it wasn't incorporated. So then there's this idea of perpetual succession, that the organisation can exist no matter individual members or staff or board members coming and going. So the organisation has continuity as in its own right to personhood, regardless of the individuals who might come and go. So we can summarise that up. It's a distinct legal entity, so it's separate from the employees, the members, the supporters, the board. The perpetual succession, it can continue to exist and is considered to be the same person regardless of membership changes. It can accumulate collective assets and it limits the personal liabilities because the organisation becomes liable for debts, for being sued, for breach of contract or whatever might occur if something goes wrong or any other obligations. You'll see there that I carefully use the word limit, not obliterate. And we'll come back to the limits of the limit a little bit later. But it does cover most circumstances. In addition, but the thing that's usually overstated is that there are some minimum requirements in legislation that could give people some certainty about how the organisation will operate. But the requirements in the legislation are very minimal. And before the Charities Act came along, charitable trusts did not have to provide a return to anyone about anything. They were obliged to meet once and a year. They had to operate consistent with their trustees. That was the minimum requirement. Incorporated societies, they had the onerous responsibility of providing a financial report in whatever form they wanted once a year. They also had to tell them whenever they tell the company's office whenever they moved house, and they also had to meet once a year as well. So they had 3 times as many responsibilities as charitable trusts. Not very big ones, as you can see. Progressively, there's been push to tighten those things up, and when the new Incorporated Societies Act comes in, there'll probably be more expectations. The Charities Act has added more expectations as well. So those minimum requirements are starting to become something substantive now. Okay, so that's why we incorporate. But even when we incorporate, we are still responsible for whatever goes on in the organisation. So that's Harry Truman with the buck stops here. He didn't invent the phrase, but apparently that was responsible to popularise it by having it on his desk when he was president of America. And that's really the ultimate rule for responsibility. Because of course, as board members, we are responsible for, if you just take one and pass it on, complying with the full hierarchy of laws. So that means technically we should know every law in New Zealand. I bet you don't. I bet you don't even know how many there are. There are lots. That's the official answer. This is a list of the kind of minimum essentials for most organisations that you need to have some basic familiarity with, and even this this kind of minimum essentials is can be fairly daunting. A really helpful resource is I'll take the extras. Right. A really helpful resource is that the first website listed, which is produced by all the community law centres in New Zealand, the Community Law Manual, and Chapter 27 is specifically about community organisations and the law, so it gives you a good overview of excuse me, of the kind of requirements that you need to fulfil as community organisations, and of course there are other laws. As I said, technically every law we need to be complying with, but these are the ones that we're more likely to brush up against. If we're ever selling anything, then we need to add to that list the Consumer Guarantees Act as well, because there are specific requirements in that, and it doesn't matter whether you're for-profit or not-for-profit. Those requirements, the basic requirements of the Consumer Guarantees Act, still apply. So if we're ever selling anything, so even if we're selling things cheaply, as long as it's clearly not a donation, then the Consumer Guarantees Act would also apply. So there's quite a few things that we need to be aware of. And we have this particular responsibility to be aware of our own constitutional trustee and to always make sure we operate within that. So I'm just going to do a little quick quiz. So how many people have got a trust deed or a constitution in front of them? Oh yeah, most of you, that's good. So if you don't, just look on to share it with someone else's trustee. And I'm just going to ask you a few questions about your constitutional trustee, or whatever you call it. Okay. So first question, how do you know you've got the right copy? You know you haven't.
So no.
Should be signed at the back.
It should be signed at the back by the chairs, but that's not sufficient to know that you've got the right copy.
The date?
The date might be a clue, but it's not an absolute test.
It's not if you had amendments made.
Yeah. You'd have to remember when the date was the last lot of amendments made. The absolute test in this is whichever one is held by the Companies Office. So every now and again it's worth going online to, I think they call it societies.gov. The website's down there at the bottom of that last sheet I handed out to you. And checking what version of the Constitution they have and what version of the Constitution you have, and making sure they are the same. And if they haven't got what you think should be the latest, you need to send them in the latest. And then they will put their stamp on it. Before the internet, and that way of checking, the stamp of the registrar was considered the proof. But the electronic register is now considered unquestionable proof about what is the operating constitution. So if you go through a big constitutional change, get all your members to agree to it, get your chairs to sign it off, print out the nice new version and forget to send it in, it's as if nothing happened. Because it has to be sent in, stamped and agreed and put on the register. That's the only official one. Yeah.
And that's for the incorporated societies.
Yeah.
What about trusts?
And it's the exact same process for trust deeds. Though you don't actually amend a trust deed. Technically what you're doing is you have a supplemental deed. So you actually have to keep adding to it. So when you think you're amending a trust deed, you are actually just adding a supplemental trust.
Where do you go to find that? Because that won't be the same as...
Yes, it is. It's the same. So the Society's website includes both incorporated societies and charitable trusts.
So I've just done a trust deed and I've sent them for charities.
Yes.
Registration. So do they send it to the Companies Office?
Yes, they have an agreement to send that to that.
I didn't know that. Right, okay.
And that was part of because by adding another layer, everyone would have had two things to send it to, which is vastly unnecessary. So when the Charities Act was first drafted, some of us pushed to get it so that they would automatically send it to the registrar.
Thank you for that information.
If sent to the Charities Commission, which is now Charity Services Unit, CIA. But this is one of the most confusing areas of law because the Charities Act doesn't incorporate you.
No.
All it does is give you the right to call yourself a registered charity and gives you a number. You can say registered charity CC, whatever that number is, and will give you access to certain tax benefits. But separately, you have to have your legal status, which needs to meet the Registrar of Incorporated Societies, the Registrar of Charitable Trusts requirements. So that's your legal identity, and this is, I like to call it your tax status or your other status.
So before you go on from there, you've got your CC number.
Yep.
So you've also got an incorporated societies number.
Yes, yes.
Cool.
Yeah. Because one is just with your registration and one is your legal entity. And for example, you can register as a charity. You can also register as a political party. If you meet the criteria for political parties, you can register as a whole lot of different
That would be good fun.
Yeah, I never had anyone come to me and when I was a volunteer at the Law Centre and wanted to register as a political party. So.
No, the hardest part is getting 500 people.
Yes, you've got to get more members. Yeah. Okay.
We can be a political party. Good.
Okay. Moving on, seeing as the conversation is starting to deteriorate. Can you find your purpose or objects? They're usually at the start. And they're usually called purpose or objects. Does anyone call them anything else? Principles?
Purpose?
Purpose?
Next page is purpose.
Usually you'd have something as well as principles, but
Yeah.
let's have a look.
Purpose is number 3.
Yeah.
We're supposed to read it.
I think it's just a.
Oh, yeah.
We just started.
That's something that I can tell my guys that we should be putting on ours, because that's one of our.
Okay, so everyone's found their purpose. It's good to find your purpose in life, I think. The reason this is important is, if you do anything outside your purpose, you are acting illegally. So it doesn't matter if what you're doing is nice, even charitable. If it's outside your purpose, you are acting illegally. And that means you lose. That's one of the grounds for losing the protection of incorporation. So that's one of the limits. So you might set yourself up as the volunteer centre of Marlborough and decide that there's poor people on the West Coast need your help, so you'll put a branch out in the West Coast. If your constitution says you are to promote volunteering in Marlborough, the moment you do something in the West Coast, you are acting illegally. Now, there's not been a case of anyone being taken to court for that, but I don't want to be the first, so you probably don't either. It really would only become an issue if something went wrong. So if you had a dispute in the organisation, or there was some conflict over money or something like that, then this could
Probably
come
some
to
other
it.
organisation in a different area that
Yes.
didn't want you stepping on
Or didn't want you
toes
stepping,
or something.
yeah. Or even someone internally, they could use that. Because what that means is if you lose incorporation, then your personal assets are at risk. So if the organisation doesn't have enough assets, hopefully there's enough homeowners on the board. That gives you something pretty worth suing for. Okay, so that's why it's really important to find your purpose. And if you are seeing the need to operate beyond your constitutional purpose, amend the purpose as soon as possible. Do you have a common seal? Or is your seal very special? Do you have a common seal?
Yeah, it's sitting right there on the copy of the page. Stamped on the wall.
In your constitution, does it say anything about the common seal? Most standard constitutions will. So what does it say? Anyone who's found their common seal paragraph? Yep. Someone like to read out their paragraph on their common seal?
Volunteer Marlborough 1 says, the common seal of the board, following its incorporation, will be kept in the custody and control of the secretary or such other officer appointed by the board. When required, the common seal will be affixed to any document following a resolution of the board and will be signed by the chairperson or a trustee acting as the chair and one other trustee appointed by the board.
Right.
So is that like your logo essentially, or?
No, it's just a rubber stamp.
Okay.
Which? You go to warehouse.
But a very special rubber stamp that you can get from the warehouse, yeah. And you can put your design on it, or you can just have your name written boringly in plain print, or you can have a circle with lines, rampant, whatever.
Some people have got those ones that like indent.
Yeah. I think they mostly went out about 3 monarchs ago.
Do you know, like they used to do the rings on the wax?
Yeah, rings on the wax. Yeah, you can use any of those methods. But what you need to do is check if there are times when you must use your common seal. Usually it's permissive rather than requiring you to. But if someone has been slack in drafting a constitution and put a must instead of a can, then every time you make that kind of decision, you've got to use the common seal, or otherwise there's your decision is not considered validly completed. And there are circumstances when you always will need to use a common seal. Purchase and sale of land is one overarching requirement. So if you're ever buying or selling real estate, you will have to use your common seal. So you'll need to know where you've hidden it and dust it off for that. And then you'll need to know what are the rules about who can use it and on whose authority after what decisions. So you need to make sure you follow those through as well. One of the arcane bits in most constitutions, but because it's there, we have to abide by it. Where is your registered office in your constitution? Not the street address. Can you find a registered office? Most constitutions will require you to have a registered office. If you've got a really smart constitution, it will say you will have a registered office and it will be determined from time to time. Or otherwise, every time you change where you keep your records, you have to change your constitution. The purpose of this is the registered office also has to be provided to the registrar of incorporated societies and charitable trusts, so that there is an official address for serving official papers, not only by the registrar but by any individual. So if an individual wants to serve you with officially with papers, they can ask the registrar, what is your registered office? And whatever the registrar sends them, if they send it to that address, that is considered officially served. So the big lesson here is, if you change your PO box or office address, or change the secretary who's receiving all the mail, make sure you tell the registrar, because anything that goes to the old one, that's whatever the registrar holds, will be considered to be officially served on you. And it's no excuse that I forgot to change it. That's the officially notified one. So that's one little thing that's worthwhile keeping up to date.
So just on the corollary of that.
Yes.
If you file a constitution with the registrar,
yeah,
and they don't put an address, or there's no address there, they should not have accepted it, should they? And therefore they're liable for accepting a document that's against the law.
Yeah, usually in the information that you need to provide them, they will ask you for your registered address. So if it's not in the constitution.
Oh right, so it's another. Yeah, okay, yeah, that's.
It will be in the covering forms.
Yeah,
So it doesn't need to be in the.
No, in fact, it's stupid to put it in your constitution, because it means every time you change, you've got to change your constitution. So usually, smart constitutions will have something like. Yeah. So the registered office will be such places as the board determines from time to time, or something along that line.
Yeah. Another question, you're giving us things that should be in the constitution, yet earlier on you said that there was only minimum requirements, I think the wording was?
Yes, yeah. These are some of those minimum requirements. Maybe they don't sound so minimum, but
if you want charitable status, there's a lot of things that you have to have in there.
I've got an example of that.
Yep.
I took over as treasurer of a charity once, and shortly afterwards we were deregistered because the previous treasurer hadn't been supplying the annual returns like they should have been, and though the warnings went to him, they weren't passed on to the rest of the board, so nobody knew that situation existed.
So he must have been the registered office.
He was the registered office.
Yes,
so that's really important.
Yeah.
Have that sorted.
And there can be any kind of legal communication, and it's considered to have been received. There's no further evidence required that has been received than that it's been sent to the registered office.
Yes. I managed to sort it out by about a day.
Right.
Numerous phone calls and that.
Well, that was very quick.
The problem solved, but
we
were comfortable to be within 1 day of being deregistered.
Yes, it's very easy for that to happen. Yeah. And the main reason for organisations being deregistered or taken off charities register is not answering mail. And sometimes the reason you don't answer mail is the organisation doesn't exist, but I bet you there's a lot of those where they just didn't update the mailing address. So that if you're taken off deregistered, if you go through that full process, then you have to go through the full process of registering again. And in between, you've lost the protection of incorporation. So you're individually responsible if anything goes wrong. Your individual assets are at risk there.
Can I ask a question?
Yeah.
Because I have here the trustee in front of me, if we need to make an amendment to one of the, or want to do it, what is the official procedure?
So officially what you do is you actually write what's called a supplemental deed, and that deed says, you know, all words after that in clause 5 be deleted and substitute the words go jump in a lake, you know, and or whatever the change you want to make. So the supplemental deed is like an amending document.
Did this go to the charities office as well to be legal?
Yes, yes, yeah. It needs to be both. Yeah.
Thank you.
Okay, so overall, these are considered the kind of legal responsibilities of board members, and none of these are written in legislation anywhere. None of these are in court cases for not-for-profits, but most of them are in court cases for commercial organisations, and most lawyers think they would probably apply to not-for-profits. There's a plan to include some of these ideas in the new version of the Incorporated Societies Act, and I think similarly will happen with the Charitable Trusts Act. So these one day may become red letter law, but at the moment they're just what most lawyers think are our obligations. That's how fuzzy it is. So there's always the obligation to act in good faith, so that you come to a meeting open to hear the evidence, make the decisions based on what you hear, and act with the best intent of the organisation at heart. You always have to comply with the Act under which you're registered and your own constitutional trustee. We can talk about that a lot. You have to exercise reasonable care and diligence, and this is kind of related to the next one, and not act recklessly nor create substantial risk of loss, especially to creditors. So this is the Jenny Shipley problem. Not exercising enough close oversight over the cash flow of the company and the legal obligations of a partner organisation to back them up, and making assumptions that they would be backed up if they lost money. So that's why she is in this court case, and being responsible for a very big payment. I've forgotten the size.
Huge.
50 million.
6 million.
6 million. Once you get over 100,000, it's enormous. It's all enormous. Yeah. 6 million, was it? Is that what you? Yeah. $6 million personally liable. Because if you break any of these things, again, you're considered to be losing the protection of incorporation. So if you don't act reasonably, if you don't act with care, or if you act recklessly, or if you trade when you don't have a reasonable chance of paying all your bills or meeting all your obligations, then you lose the protection of incorporation. So that's why she's liable to that payment personally.
She would have insurance covering that.
She does, and she'll never be insured ever again. Yeah. No, she will never be able to operate as a company director effectively.
Probably a very good thing.
Unless she wants to cover the risk herself, but because the insurance companies really wouldn't touch her. And there'll still be a very large excess, which would probably be enough to blow our minds. So these are the general expectations that we need to meet. The one last thing that I want to talk about is that we also have to meet is to avoid conflict of interest. And I just want to talk about exactly unpack what that means, because it's a frequently misunderstood concept. So, any ideas about what you think a conflict of interest is while I blow my nose discreetly? Monetary gain?
A conflict of interest where you've got things on both sides, and so you could make a decision that's not in the best interest of the organisation.
Yes, yeah. That's the key thing is the word conflict. So a conflict of interest is essentially where there's potential for a conflict between your own personal interests as a decision maker and the organisation's best interests. So whenever there's potential for those to be in conflict, what's best for you individually and what's best for the organisation organisationally, and you are a decision maker in the organisation, then that's called a conflict of interest situation. Does that make sense? So people think that conflicts of interest are bad. They are not. Conflict of interest are like gravity. They just happen. It's how we respond to them. It's either good or bad. So there are good responses and there are bad responses to conflict of interest. So it's no judgment to have a whole lot of conflicts of interest. And I know in small communities, you can't move for conflicts of interest because people are related to each other, know each other, are on each other's boards and that kind of thing. There is nothing wrong with having conflicts of interest as long as you follow the 3 simple rules for correct handling of them. If you lapse in any one of the rules, you can be in trouble. And again, it can mean you lose the protection of incorporation and be personally liable for anything that goes wrong at the time. So, conflict of interest itself is not necessarily bad, but how we respond to it is really important. And the first rule is we need to declare it. So this is based on the philosophy that when things are hidden, bad things can happen. So, you know, the sunshine disinfects the worst situations. So if we're transparent about the conflict of interest, then that's the first step to handling it correctly. So if we find ourselves in a conflicted situation, it's our obligation to declare it. However, if another board member knows of that conflict and we don't declare it, it's also their obligation to declare it as well. So it's anyone who knows of the conflict or potential conflict's obligation to declare it. Usually we rely on the person involved to declare it themselves first, but if they don't, everyone else who is aware of it is responsible for declaring it. So again, that means if we don't fulfill this requirement, we open ourselves up to losing the protection of incorporation and being individually liable. So keeping quiet when we think there might be a conflict of interest can expose us to personal liability if anything goes wrong.
What does declaring it mean?
So, okay, that's good. So usually that means having it recorded somewhere. It doesn't technically require to be recorded. Just someone can say, oh, you know, I've got this. But if you record it, you've got evidence that it was declared. So I always recommend that you record it. And there are basically 2 ways of recording it, either in the minutes of meetings or having a conflict register. And that's an official register of the board. And it's available for all board members to see. Because again, there's no point in having a secret register, because that defeats the purpose of it being declared to all the other decision makers. It doesn't have to be publicly declared, but it does have to be declared to all the other decision makers. You can declare it publicly, but that's not a requirement. The second requirement is that the potentially conflicted person stay out of any decision or attempt to influence the decision above and beyond which a normal citizen or member might be able to influence. That bit is in there so that if you were applying for a job with the trust and you were a board member, you could say, oh, I'm going to sit down as board member while this is considered, and I won't be involved in picking the board member, picking the employee because I'm one of the applicants. But I would like to write an application, which is obviously trying to influence that you get the job. But writing an application is available to any other person in the situation. So apart from that, you have to absent yourself completely from the decision or trying to influence. So technically this also means that you're not allowed to sit in the room and nudge, nudge, wink, wink, or any other means of influence.
How does that work if you've actually got a great deal of knowledge about the intended path? If that's your background and someone only wants to go that way, you try not to influence them, but you're trying to protect them from making the wrong decision because you already know how that's working.
Yes, yeah. So I'll just back a little bit because it is a difficult issue about sharing information that you think will be helpful to the organisation. One of the ways, so not being involved in the decision only means that you don't vote or discuss in the decisions, or haven't been involved in discussion around the decision. But I always recommend that people physically leave the room, and again, to make it for surety, to record in the minutes. Garth left the meeting at 8:20. We discussed purchasing a new Garth-later, and decided not to. Garth re-entered the room at 11:45, fuming. Whatever. So that you've got a record that I was clearly not in the room or trying to influence the decision making.
Only where the conflict of interest was.
On the conflict of interest, yeah. On the issue that you're conflicted about. If you have information, it might feel like you're being helpful in giving information to the board, but if that information is able to be interpreted as favouring your interests, it's sailing perilously close to the wind. So you might have to snub or deny the benefit of your knowledge, just to be absolutely safe. It's a bit of a kind of blurry area, but the more that you can be seen to be trying to influence a decision, and that a decision one or another could be to benefit you personally, if it smells like a conflict of interest and looks like a conflict of interest, it's probably going to be considered a conflict of interest. So so that's some of the trade-offs involved in that situation. The third, and you have to remember, you have to do all three of these things, is to make sure that any financial payments or anything of financial value, so you can't get around this by giving people gift vouchers or petrol or lollies or whatever, anything that has financial value, are at market rate or to the advantage of the organisation. So this means that if the organisation has a whole lot of second-hand computers that it no longer needs and it was going to put them on the dump, and you say, oh, we don't have a computer at home, I'll take one of those, you're immediately in a conflict of interest situation. So you need to declare it, you need to stay out of any decision making about whether you get to keep one of those, and so preferably leave the room. And you need to pay, if you're going to buy that computer, market rate or higher for the computer, because it always has to be to the advantage of the organisation, not to the individual decision maker. So this is part of the cost of community service. If you were an accountant by trade, there was a vacant position over a critical period in the financial year, and you said, look, I'll step in to do that for a month just to keep us ticking out until we recruit a new person for that job. You have to declare a conflict of interest, you have to stay out of decision making, and you have to be paid market rate or less, because it always has to be to the advantage of the organisation. Does that make sense? Yeah. Okay. So it does get complicated in some situations, but they're fairly straightforward rules mostly to apply. They may force us to do things we're uncomfortable with, like not give information that we think the organisation needs, but if we want to play safe, we will be pretty rigid about these 3 rules, because being found to have acted improperly in handling a conflict of interest, or even being thought to have done that, can be damaging to the reputation, and if legally found to be the case, you can lose the incorporation, protection of incorporation. So it's not a trivial thing to think about. People often think...
I've got a question.
Yep.
How do you handle the situation then if somebody has a conflict of interest pointed out to them and they don't acknowledge that it is a conflict of interest?
So they're a decision maker with the others. So so say they're a board member and the rest of the board says, oh no, we think this is a conflict of interest. And it's, oh no, I don't think it is. And then it's, well, let's take a vote. All those who think it's a conflict of interest. And as soon as it is a conflict of interest, so if the majority agree, then all these things have to apply. So someone else can declare it, but the person has to be out of the decision making. So we can say, we appreciate you don't think this is a conflict of interest, but we want to err on the side of caution and make sure that there can be no accusations about us acting improperly. So for the good of all, it's probably best if you're not involved in this decision.
So there's 2 steps for the person who's not particularly involved, and that is they've got to say, I think there's a conflict, and then the board has got to agree.
Yeah, if the person themselves is not taking that action.
Right, okay.
Yes.
Yeah, that's what he asked for.
Because otherwise a rogue person would just say, conflict of interest.
Yeah, that's right. Yeah, so there is 2 steps there, isn't it? Yeah.
So the whole board has to agree it is a conflict of interest. Yeah. If someone's disputing it. Yeah. If no one's disputing it, then it's considered agreed anyway. One of the things that comes up with conflict of interest is relatives. Husbands and wives, daughters, sons and lovers, all of those kind of things. And again, this is a particular issue for certain communities. I was trying to find the least offensive photo I could. I didn't succeed. You might be pleased to know, I did at least decide to choose a non-New Zealand community. I won't name any, you could fill in the blanks yourself. For related persons. There are rules about related persons. And interestingly, they follow the rules of, if I can pronounce it correctly, consanguinity, who you're allowed to marry. So if you're close enough to marry the person, you're too close. If you're close enough not to marry the person, you're too close. So in New Zealand, that's 4 degrees of separation. And this is, of all things, in the Tax Act. And it takes about 10 pages to explain this, because they can't use diagrams in law. They use words. I don't know whether they can't, but they don't. It's much simpler to use a diagram. So you have a diagram of this family tree. So if you look at this family tree chart, and essentially, if you're within 4 degrees of separation, then you're considered a related person. So if the conflict is with a related person, it's considered to be you have a conflict. So if I'm a board member and there's a person within 4 degrees of separation who is applying for the job or who is buying the computers or whatever, then I am considered to be in a conflicted situation. Does that make sense? Yeah. How you measure this is you use the Māori concept of whakapapa. You go back to a common ancestor. So this is one of the pieces of tangata whenua culture embedded in our laws. I don't know why they picked this bit, but so brothers and sisters are not 1 degree of separation, they are 2 degrees of separation, because you have to go back to a common ancestor. And cousins are, so here Alex and Chris is 1, 2, 3 degrees of separation, because you have to, Kim is the common ancestor. Does that make sense? So you can't go across family trees. You have to go back to a common ancestor to count the 4 degrees of separation. So if Jean is a board member who is released from obligations about potentially leading to a conflict of interest in this chart. So Jean is the decision maker. So who's outside of 4 degrees of separation? Jean. So if we're going back to common ancestors, so 1, 2, 3, 4. So Chong is included. So all these people are included, but Alex, Robbie, Sam, and Joe are not. Okay. So you can kind of get a feeling why it takes 10 pages in the Act to explain this. But, it's much simpler. I find it much simpler in the diagram to count back. Now, as with all things legal, there's always a proviso. Marriage. They take the biblical view of marriage. The 2 shall become 1. So there's no degrees of separation between a husband and a wife, or a husband and a husband, or a wife and a wife, or a civil union couple, or a de facto couple. No degrees of separation. So the sister in law has the same relationship as the sister, because there's no degrees of separation between the married couple or the de facto couple or the civil union couple. Adoption is considered like as if it were a blood relationship, so they just fit in the same way. Whāngai, there's been no cases about it. People assume it might be like adoption, but then they say it's a little bit different from adoption, and it essentially means that a person will have 2 relationships with one person. So which one do you count? I don't know. You could be the first law case to test that. Spend your life and fortune in the High Court of New Zealand if you wanted to. I think that's the main exceptions.
So the reality in a small town, if Joe and Jean had the same surname, and they said to Jean, "Isn't Joe a relation of yours?"
Yes.
But the 4 degrees rule doesn't apply.
Yeah.
Would the reality be that Jean would probably be still best to step aside just in case?
Yes. So what the law does, it prescribes the minimum. The minimum that you are required to do. You can always do more. And as you say, perceptions are often just as important as what actually is happening. So if this is going to ruin the credibility of the organisation, well, then let's do it. That's too big a price to pay just to be legally correct, or to insist on your legal right, unless there's some other strong reason for it. So the law just prescribes the minimum, and then you need to make a judgment call about reputational issues. Yeah.
But again, we can have the conflict of interest as long as we declare it.
Yes, yeah. And as I said, there's nothing wrong with a conflict of interest, which is that's the big misunderstanding. People think a conflict of interest is a bad thing. And there's nothing wrong with a conflict of interest, it's how you handle it that is either good or bad. So as long as you go through the 3 steps, then even if there is a conflict, that's perfectly fine. That's considered good practice. Okie doke. Now, I'm looking around for it's exactly 7:30. So that's where I was going to finish. It doesn't leave me for 5 minutes for any other questions. But if you do have any other questions, I will be around. Next month's topic is the board's role in setting strategy. So we'll come back for the exciting work of strategy direction setting, and especially trying to think about the board's role. Also, just a reminder to people that there is a little bit of this project that can buy some of my time for one-on-one consulting, coaching or advice. And so I can, because I'm based in Christchurch, this obviously adds a degree of difficulty, if not a degree of separation. So I'm happy to do stuff like with one or two people over Skype or Zoom or whatever you prefer to use. Or also, I have in Nelson, I've come to like a board meeting the night before or stayed over the next day for a board meeting. Or in one case, the organisation thought I was so fabulous they paid for me to come, they paid the travel costs for me to come up to a meeting. That's not my performance indicator, so I'm not worried if you don't. But we can use that time that is useful for you if there are issues, governance-related issues. It could be the manager, it could be the chair, it could be board members who are seeking advice.
How do people get in contact with you guys?
I usually try and hide. But the best way is to email me because I do travel around a bit and you never know where I might be on the end of the phone. So it's just garth@lee.org.nz. And I've in fact even now got my new supply of cards, so if anyone wants one I can give them to you afterwards as well. And I think that's all we need to do. Thanks.